कैसे हो? ठीक ठाक हो?
जी सर।
कहाँ, बयाना से हो क्या?
जी सर।
तो अभी बयाना में रहते हो?
सर अभी एजुकेशन पर्पसेस के लिए जयपुर में रह रही हूँ सर।
अच्छा,
जी सर।
जैसे पहले बयाना में स्टडी की?
यस सर।
क्या चीज़ मशहूर है बयाना की?
सर बयाना में सर फोर्ट है, वो एक वहाँ का लोकल वो मशहूर है सर। और सर वहाँ पे एक लाल पत्थर पाया जाता है, वो सैंडस्टोन फेमस है जो लाल किले में भी यूज़ हुआ है। एंड सर वहाँ पे सर एक बान बरेठा करके एक डैम है, वो भी बन बरेठा करके सर डैम है, वो भी फेमस है।
कोई मिठाई भी मशहूर बताते हैं बयाना की?
सर कलाकंद फेमस है बयाना का। जी
तो
सर।
मलाई के लड्डू जिनमें मिश्री
यस सर, मलाई का लड्डू भी फेमस है
मशहूर है ना?
जी सर, वो भी मशहूर है सर। जी सर।
तो उसके बाद कॉलेज एजुकेशन यहीं से हुई?
सर NLU पटियाला से।
NLU पटियाला से हुई
जी सर,
है ना?
यस सर।
अभी LLM परस्यू कर रही हो क्या?
Sir, I have completed the studying part. I have also given the examination, but the result is awaited as of now. Yes, sir.
तो IOC कॉन्ट्रैक्ट एक्ट में देखा होगा, स्टडी कॉन्ट्रैक्ट एक्ट का कंटिन्यूइंग गारंटी।
Yes, sir. So, continuing guarantee is defined under Section 129 of Indian Contract Act. It says when a guarantee extends to a series of transactions, then it is a continuing guarantee. So, for example, when a person is guaranteed to work for a month, and then for his good conduct a guarantee is given, then this is a continuing guarantee. So,
and void and voidable contract.
Yes, sir. So void and voidable contracts are defined in Section 2 of Indian Contract Act. Void contracts are the contracts which are not enforceable law, agreements which are not enforceable by law, and voidable agreements are the agreements which are enforceable at the instance of one party and one or more parties, and not at the instance of one or more parties.
एनफोर्सेबल हो तो उसको एनफोर्स करने के लिए क्या करेंगे? स्पेसिफिक परफॉर्मेंस के लिए कोई सूट लाई करेगा, क्या करेगा?
Yes, so if it is enforceable, if the person does not want to get it declared voidable, then he may proceed in the normal manner and file a suit for specific performance. However, if he wants to get the contract declared to be void, then he must file a suit for declaration of the suit to be voidable.
Limitation for specific performance.
So, sir, although I'm not entirely sure, but I think it is of 3 years.
3 years.
Yes, sir.
3 years of counting from when?
So since the date of specific performance. So since the default is made. Yes, sir, in specific
and
performance.
And the cause of action arises.
Yes, sir, then the cause of action arises. Yes, sir.
Constructive res judicata or res judicata?
Yes, sir.
The difference between?
So constructive res judicata is given in explanation 4 of section 11 of CPC, and it states that matters which ought and might have been raised, which are not actually raised before the previous court, are to be considered while taking care of the res judicata, and hence such matters are not to be tried in the subsequent suit. However, in normal res judicata, the matters have already in reality which are substantial and are also raised in such matters. Yes, sir.
Judgment pronounced by without jurisdiction court.
Yes, sir.
Whether it is counted as res judicata in separate another suit?
Sir, there are 3 types of jurisdiction. First is territorial jurisdiction, another one is pecuniary jurisdiction, and the third one being subject matter jurisdiction. Sir, it is being said in a landmark case of Supreme Court that the deficiency in the subject matter jurisdiction strikes at the very base root of the suit. Therefore, it is void if the subject matter itself is different than that of court which the court is competent. However, in case of a territorial and pecuniary jurisdiction, it is not void per se, and it, however, under section 21 of CPC, it may be adjudicated as void in certain circumstances.
We've gone through Rajasthan Rent Control Act.
Yes, sir. I have.
Grounds क्या क्या हैं किराएदार?
Sir, eviction suit के grounds सर 9 सेक्शन 9 ऑफ रेंट कंट्रोल एक्ट 2001 में गिवन है सर. इसमें है नॉन पेमेंट ऑफ रेंट फॉर 4 months, दैट इज़ वन ग्राउंड. सेकेंड वन इज़ सो essential repairs for conducting essential repairs, and so bona fide requirement by the owner, and so other being nuisance, when nuisance is created, and also when a residential premises is being used as commercial premises, and so there are also many other grounds. So but I'm able.
Any special provision for military men or armed forces?
Yes, sir. So special provisions for military men and armed personals are given in Rent Control Act. I'm unable to recall the exact section number right now, but it is stated that if they apply for granting of possession of residential premises for their personal use either 1 year before or after their retirement or discharge, then they are entitled to get the possession of the rented premises.
Tenant evicted for bona fide necessity of landlord.
Yes, sir.
Bona fide necessity.
Yes, sir.
और बाद में bona fide necessity जो बताई गई,
yes, sir,
उस काम में लैंडलॉर्ड नहीं लेता है.
Yes, sir.
तो whether tenant can get possession back?
Yes, sir. There is a provision for getting possession back. So I think it will be proceeded as per section 16 of Rent Control Act as mentioned in section 9 of Rent Control Act. Yes, sir.
What is the standard rent?
So standard. So may I take a moment to think about it? So although I'm not sure, but the rent in any in a rent agreement is any rent which is decided between the between the tenant and the landlord. And sir, are you asking about the increment in rent or
standard rent?
Where rent is excessive?
Yes, sir.
Or where rent is very low?
Yes, sir.
Or where rent is not agreed upon?
Yes, sir.
In condition.
Yes, sir.
Rent excessive, rent low, or no rent decided between parties.
Sorry, sir.
उसके बाद में फिर अप्लाई करते हैं कोर्ट में. टेनेंट कर सकता है, लैंडलॉर्ड भी कर सकता है.
Yes, sir.
रेंट आप फिक्स कर दीजिए.
Yes, sir. Yes, sir.
टेनेंट कर सकता है कि रेंट बहुत ज़्यादा है, एक्सेसिव रेंट है. लैंडलॉर्ड कर सकता है कि रेंट बहुत लो प्राइस पर है.
Yes, sir.
या कोई रेंट एग्री अपॉन नहीं होता पार्टी के बीच में. कई दफ़ा रेंट पे दे दिया कि दे देना, आप रेंट देना, बाद में देना, और डिस्प्यूट होता है. तो दोनों में से आइदर पार्टी वो अप्लाई करेंगे तो कोर्ट फिर स्टैंडर्ड रेंट को फिक्स करता है.
Okay, sir. Sorry, sir.
You mentioned that you are doing LLM. So
Yes.
what is your specialization?
Ma'am, I'm specializing in criminal law.
Criminal law.
Yes, ma'am.
Okay, just tell me a difference between the crime and the offense.
Ma'am, crime need not be backed by law. It is not necessary that it should be penalized by law. However, when an offense is any act which is penalized by law, for example, when a person is dying in a swimming pool and a ex person knows swimming and he does not save him voluntarily, then it is not an offense because it is not so declared as an offense by our legislature and parliament. However, it might be considered as a crime by the society because it is wrong in the eyes of society in general.
So what's the role of morality in the criminal offences?
Ma'am, I believe that to some extent the offences flow from the general consciousness of the society. Hence, there are certain countries in which a particular act is criminalized. However, in other countries the same act is not criminalized because it depends on the overall development of the society and the overall mental status of the society. And hence, Hence, there is some aspect of morality which is involved. However, there are certain acts which are, although considered moral or fine by the society, but which are not fine, such as dowry, such as sati. Hence, it is a balance between morality and the right thing to do.
Can you just tell me one difference between the culpable homicide and the murder?
Ma'am,
What is the line of demarcation? How we differentiate?
Ma'am, the basic difference between both of them being the gravity which is there. In both cases, there is an intention, and even the intention in murder is so grave that that the person knew that he will cause death. But in culpable homicide, the probability of causing death was pretty low. It is said that when an act is done with the intention that it is likely to cause death, then it is culpable homicide. And when it is done with the intention that the offender knows that in all probability it will cause death, then it is murder.
So only two words makes a difference, likely or probable.
No, ma'am, there are other differences also. For example, in there is a knowledge aspect also, that in culpable homicide that the person knew that had knowledge that his act will likely to cause death. But in murder, that the act was in ordinary course was sufficient to cause death. Even such knowledge is sufficient to constitute the offence of murder.
Okay, just tell me why we have the two kind of different minimum and maximum concept in the criminal. What is the concept behind having a minimum punishment for the same offence and the maximum? Why we have made this?
Ma'am, although I'm not entirely sure, but I believe it is because so that there is a uniformity in the sentencing practices, because there is a state judiciary in India and there is a huge variety of magistrates in all over the country. So as to maintain a uniformity in sentencing of an offence. Therefore, minimum and maximum punishment is prescribed, and the difference is between the maximum and minimum punishment is given so as to give a little scope for the judge to decide according to the gravity of offence. For example, in a grievous hurt offence, if a person is hit only one time by a stick, then he is entitled to a lesser punishment. But if the same person hits him 50 times or 40 times and still the offence of grievous hurt is made, so he is entitled to get an enhanced punishment for the same. That's why there is a
Last question. What is the cardinal principle of criminal law to commission?
Ma'am, the cardinal principle of criminal law is that
There is one maxim which we consider as a cardinal principle for criminal law.
Okay, ma'am. Ma'am, that there should be a presence of mens rea, that nisi. Ma'am, I'm unable to recall the maximum as of now, but it states that
If you can recall, I'll give you a hint. Coke has given one maxim for this.
Yes, ma'am. Ma'am, it has words like nisi, mensi, tria that I'm able to recall. Yes, ma'am. Yeah, ma'am, but I'm unable to recall the entire maxim.
Ayushi, what are the provisions of impeaching the credit of a witness
Okay, sir.
in Evidence Act?
So there are three provisions for impeaching the credit of the witness. Either it's by producing a witness who can give a testimony for his bad behavior or for unworthy credit, and also so other can be by showing that he has contradicted from his previous statement, and so the third one I'm unable to recall right now, sir.
Can you recall the section of that?
So I think it's 140, 147 or
155?
155. Yes, sir, 155, section 155 of Indian Evidence Act.
154?
So 154, section 154 talks.
145?
So
There are many sections. No?
Yes, sir.
Cross examination,
Yes, sir. Corroboration, yes, sir.
contradicting
Yes, sir.
her or his previous statement,
Yes, sir.
If the witness is hostile, then cross-examine.
Yes, sir, I'm able to recall now. Sorry, sir.
Do you know about the pardoning of an accused?
Yes,
in
sir.
the CRPC?
Yes,
What
sir.
are the provisions and
So,
definitions of that?
So section 306 of CRPC talks about pardoning of an accomplice so that he may become an approver and hence a government witness. In this, a person who is generally part of the offence or is a privy to the offence is pardoned on the condition that he will make a full disclosure of the offence, and in the process he will also name all the persons who are directly or indirectly concerned with the offence, and the same powers can be exercised by the Sessions Court during trial under section 307 of CRPC, to the best of my knowledge. 307 or 308, sir, I'm entirely not sure.
Suppose that accused is not giving the full details of the offence, then what are the provisions regarding that?
So the first provision, which is that he may be tried separately for the offence, and such he shall not be tried without the permission of the state government if such an for giving false evidence, and he may also be tried for the offence for which he was pardoned. Yes, sir.
CPC में जो अपील के provisions
जी sir.
हैं, उनके बारे में थोड़ा बताइए.
So there are many kinds of appeals and different provisions which are dealt under CPC for appeal. First is the first appeal, which is governed in Order 41. Second one is second appeal, which is governed under Order 42, which is appeal to the High Court. Third one is appeal from orders, which is governed in Order 43, and appeal by indigent person is governed in Order 44, and appeal to Supreme Court is given in Order 45 of CPC. So should I further expand?
Yeah.
Yes, sir. So in the first appeal, generally the general rule is laid in section 96 also, that all decrees are appealable per se, and hence first appeal is maintainable. However, second appeal is not always maintainable. It is given only when the case involves a substantial question of law, and hence and the second appeal only lies to High Court. And in cases of appeal from orders, not all orders are appealable. There is no concept of second appeal in appeal from orders, and only first appeal is maintainable only with respect to orders which are mentioned in the section and as well as in the Order 43. And in case of appeal by indigent person, any person who appeals as an indigent person cannot.
These are the special provisions.
Yes, so they are the special.
Yes. What's about 151 CPC?
So it is an inherent power of any civil court to prevent. It is used for the twin purpose. One is to prevent the abuse of process of court, and second for upholding the justice in the interest of justice. That's are the two grounds for section 151 of CPC.
Ayushi, any other inherent power is given in CPC?
Yes, so there is an entire chapter which is dealing with inherent powers of civil court. For example, section 149, to the best of my knowledge, deals with
149 or 148?
So 148 also, and 149 deals with deficiency for clarifying the deficiency in court fees, and also in section 148 talks about increasing the time period in cases up to 30 days by the civil court.
Okay.
Yes, sir.
Ayushi, what is morality?
Yes, sir.
And can morality be liable to declare any contract void?
Yes, sir. So under section 23 of Indian Contract Act, if a contract is opposed to the public morals or public policy, then it is a void contract. For example, a contract which which forwards and supports prostitution is usually considered.
Any definition is given in any act or in any case?
Sir,
As you gave the situation prostitution, any other definition is given?
So there have been certain instances which have been included by the Honorable Supreme Court, such as adultery. A contract to live in adultery has been declared as opposed to the public policy and public morals, but I am unaware about any such definition, sir.
मान लो आप मजिस्ट्रेट बन जाते हैं
जी सर.
और तब किसी से आप ये कहते हैं कि भाई ठीक है, एक सिलेंडर मेरे मैं वापस दे दूंगा, आपको दे दूंगी सिलेंडर, एक सिलेंडर ख़त्म हो गया है, मेरे को भेज देना। अपने उससे सब इंस्पेक्टर को या पुलिस वाले को बोलते हैं, इज इट इमोरल?
So to some extent, yes sir, it is immoral because there has been a limitation which has been fixed by the government for number of cylinders which may be purchased by a domestic user. Hence, if I exceed that limit and if I illegally procure such cylinders from some other person, then it is violation of that.
Okay.
Yes, sir.
I am giving a situation
Okay, sir.
related with IPC.
Sir.
एक आदमी है
Yes.
और जो सामान्य अंगूठियाँ बेचने का काम करता है,
Okay, sir.
एक गांव में जाता है, अंगूठी बेचता है
Yes, sir.
और एक आदमी उससे अंगूठी ले लेता है, बोले बहुत अच्छी अंगूठी है और ये पानी वानी में काली नहीं पड़ेगी, लेकिन गोल्ड की नहीं है, ये उसने एश्योरेंस दिया और उसने अंगूठी ले ली। 2-3 दिन में वो पानी वानी में काम करता था, वो अंगूठी काली पड़ गई। बड़ा गुस्से में था वो व्यक्ति कि अब क्या आएगा तो उसको देखूंगा। और थोड़े दिन बाद फिर वो अंगूठी बेचने आया और उनकी कहा सुनी हुई थोड़ी बहुत, तो उसने एक छोटी सी छोटा सा कंकड़ उसके मारा और सर में ऐसी जगह पे लगा कि थोड़ी देर बाद ही वो बेहोश हो गया और डेथ हो गई। क्या ऑफेंस है?
So, I think so. The offence will be grievous hurt. Hurt.
नहीं,
or
ग्रीवियस हर्ट के जो ग्रीवियस हर्ट कौन से सेक्शन में दिया हुआ है?
सर डिफाइंड सेक्शन 320 में है और पनिशेबल 325 और 326 में है और 326 A एंड B में भी एसिड अटैक वाला एस्पेक्ट पनिशेबल है।
ग्रीवियस हर्ट की डेफिनेशन दे रखी है
सर
ना?
320 में है सर।
320 में दे रखी
Yes,
है,
sir.
तो उसमें तो कहीं कवर होता नहीं है।
सर हेड का यस
आप देखो
यस सर उसमें सर हर्ट होगा फिर सर बट
तो
मर्डर
उसने क्या मर्डर कर दिया?
नहीं सर मर्डर और कल्पेबल होमिसाइड नहीं होगा सर, क्योंकि ना इंटेंशन था ना नॉलेज थी, क्योंकि वो इतना इनसिग्निफिकेंट पत्थर था, पेबल था सर, तो इसलिए मुझे लगता है कि सर वो मर्डर या कल्पेबल होमिसाइड नहीं होगा।
तो सिंपल हर्ट।
यस सर।
एंड व्हाट इज डिफरेंस हर्ट एंड इंजरी?
So hurt is a wider term. It includes injury.
हर्ट वाइडर टर्म है?
Yes sir, it
या
includes
injury?
so hurt के definition के अंदर से bodily injury आती है।
और इंजरी की डेफिनेशन?
So sir I'm unable
इन
to.
विच सेक्शन?
So उसमें sir I'm unable to recall the exact section number
सेक्शन 44।
of yes sir. So yes sir, उसमें even the mental part is also included in definition of injury. So sir I'm not entirely sure sir.
ठीक है सर।
ठीक है sir, thank you sir. ठीक है, नमस्कार sir.
एनी सजेशन सर?